Good evening and welcome to the brief on Near FM, Ireland's only legal affairs show. Your hosts tonight are barristers Andrew Robinson and Peter Leonard. Good evening, Peter.
Good evening to you, Andrew. Great to be with you this evening.
Absolutely. And Peter, you're not on your own with me tonight. We've got quite a few guests coming on to the show this evening. We're going to hear briefly from Ross Maguire, Senior Counsel from New Beginning later in the show. We also have Dermot Walsh, and he's a Professor of Law with Kent University. We also have Ken Murphy, the Director General of the Law Society. Paul Tweed, international libel law par extraordinaire, talks to you later, Peter. And in the studio we have Lauren Kearns, Barrister at Law.
Well, Paul Tweed is a leading lawyer in this area, and he's been on the case of these ISPs, I think they're called. Is it ISPs?
Peter, you're showing your age. The Google.
On Google and all these search engines, that's the phrase. And he's been on the case of all these search engines who are not playing ball when they get it wrong. And first of all, I asked him to direct his comments towards this case in relation to Google and Thomas Byrne.
The basic principle here is that the plaintiff had to go in to obtain an interim High Court order in order to stop Google from publishing the photographic image, which was incorrect, obviously, and it was of the convicted solicitor. What this highlights is an ongoing problem that we lawyers are faced with on a daily basis when we are trying to get the cooperation of Google or any of the major internet service providers or the social networking sites. The problem is they will not do anything normally unless we obtain a court order. That takes time. And although Facebook have recently been introducing procedures that assist in alleviating this problem, it is a difficulty that, unfortunately, with time being of the essence when you're dealing with an internet publication, because bear in mind this photograph will have gone around the world in a matter of seconds, so no matter how quick Senator Byrne's lawyers have moved, much of the damage will already have been done.
Okay.
And the problem is that up until recent times, the likes of Google would have been based in the United States and would be applying First Amendment principles to their stance when somebody asks them to remove either a photograph or an article, and normally they will not do it unless a court orders them to do it.
Okay.
An interesting analogy, of course, is last year when the Google Brazil made what were regarded as offensive comments regarding a senior Brazilian politician. The politician, whenever he put them a notice and requested to take it down, Google initially said, oh no, there's nothing they could do about it. They could not take the material down, and it was only when they were threatened, when the head of Google Brazil was threatened with imprisonment, that suddenly they found a way of doing it. So this is really a question. The issue here is, why can't the ISPs, the major ISPs, not have a system in place where if their attention is brought to something like this, and this is like, a very blatant and obvious mistake, which, could cause and would have serious consequences for the politician involved.
Well, I noticed Mr. Byrne's counsel, Jim O'Callaghan, he said that the publication, in his opinion, it was a mistake with no malicious intent. And so he said that they got on to Google and they asked Google to correct the error, and that Google apparently has some sort of self-correcting mechanism that they tried to use, but to no avail, and unfortunately were forced into court. It seems like that it's just a willful failure to sort of comply with good behaviour in relation to these matters.
Yes, it's a common failure with them. We have this difficulty on a regular basis, and most lawyers will confirm the same, that, you get a standard reply back saying, in the absence of a court order, there's nothing we are prepared to do or can do or whatever. And this is a problem, and this case highlights that. Now, fortunately, they were able to get an interim order restraining Google, but as I said, in the era of the internet, this information goes around the world so quickly. Unless the ISPs are prepared to act with the same speed that their information is disseminated, then a lot of the action a court takes is largely too little, too late. And the problem is that even damages, whenever they're awarded, it could take a year and a half to get the case into court. And people who have viewed either the offending photograph or the offending caption or the offending article will already have formed a view.
Okay, now can I just ask you specifically in relation to the defamatory content here? Mr. Byrne is well known. I mean, so people who see his picture, the fact that he's well known, does that lessen the libel and defamatory content in this instance? Because if he was an ordinary individual that nobody knew, they could say, oh, well, that's Thomas Byrne. But when they see him, they say, we know him. He's a Fianna Fáil politician of long standing.
Well, again, it would be inappropriate for me to comment on a specific case which is still to be, tried by a jury in due course. But in general terms, it's all very well saying, oh yes, a close circle of people, and with a close circle of people in terms of the World Wide Web, Ireland would be regarded as a small number of people. The difficulty is it's people in the broader worldwide community who see these things will not have the knowledge of knowing, what an individual looks like or should look like, but may have had an association or contact with them in the past, or the name may have some bearing on either a business deal they're doing or a banking arrangement they have. So the difficulty is that, with such a massive group of people that the World Wide Web disseminates to now, there is no way, or you can no longer say that, local knowledge means that people would know better or would know that this man wouldn't do this or whatever. That no longer applies in the same way that it would have applied, say, 10 years ago when we were dealing primarily with the print media.
Okay, very good. And can I just ask you about Section 33 of the Defamation Act 2009? This would appear to be quite an effective mechanism in a scenario like this.
There are effective mechanisms under the law, and the law will get you there in the end. And there are various options are being looked at now in a number of countries as to how the law can work quickly and effectively and put the onus. And this is the whole issue here. To put the onus on the ISP. They are the people with the control. They are the people who have the ultimate decision as to what is allowed or the type of material that is posted on their service. And so really the law is gearing itself towards putting that onus on them while giving them an opportunity, because of the sheer volume of material that is on there, that once they've been put on notice, to act quickly in response to any legal remedy that may be put to them.
And Paul, can I just ask you, you're obviously to the forefront in highlighting this difficulty with internet publications, and you have raised this point time and time again. What will bring about change? Will it be very substantial awards made against the ISPs? Is that how change comes about, or is there any other way to effect change?
Well, certainly in the traditional print media era, the only thing that worked, in my opinion, was a deterrent of a substantial award of damages. That's the only thing that made, editors think twice or to exercise more care before they publish. So, I've every reason to believe that that's the only remedy that's going to work with the ISPs as well. They've got to see something that's going to hit their pockets hard. But of course, when you're talking about major international organisations such as Facebook, Google, or whatever, even the threat of an award of €1 million is not exactly going to have them quivering in their boots. So the problem is, it's got to be a two-pronged approach where there's got to be a procedure in place where the